Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, the place where we not only talk about what's going on in the gun world, but also how we're going to fix it together. And the content today is going to start your week, your month off right, because the Supreme Court has just decided to take up a case which could overturn Chevron Deference. This cuts the ATF's power completely. Everything will be linked in the description box below, and this one, I need you to watch the whole video because it is massive. And if you are new or you are a returning viewer, please consider hitting that like button, subscribing to the channel, and making sure you turn that notification bell on. We need as many of you as possible to get into the fold with us so we can pass the blessing of the Second Amendment along to the next generation with content just like this. All right, so before we get into this, I'm sure you guys are aware or you are not aware. I had a little bit of a food poisoning or a food allergy. I had something bad that took me out yesterday, and I thank each and every one of your kind words in the post that I made explaining why I wasn't here. But I come back with a vengeance today. I'm still under the weather, but just in time for this to lift my spirits, and I cannot wait to hear what you guys think in the comments field and spread this one out because this is massive. This is like Bruin 2.0. Get this, check this out. Supreme Court takes up case to review agency deference, potentially overruling Chevron. Now, if you're not familiar with this, very high level, Chevron deference is an interpretation of existing law that federal bureaucracies can make to change the law effectively. The ATF uses this a lot. You've got the pistol brace rule, you have ghost guns. That's just a few of the examples. That's the stuff that they have been doing recently. And you also got, I think I said pistol brace. Yeah, pistol brace, the ghost gun thing. Yeah. So this is a big part of their source of power. Everything that they've done recently has been through this Chevron deference because they're changing definitions and they're changing words and their meanings in order to achieve a different means. That's what's happening here, and the Supreme Court is about to look at it. They just took up the case. This is massive, guys. The Supreme Court on Monday took up a case that could strike a blow to federal agencies' power, giving the High Court an opportunity to overrule decades-old precedent that has permitted courts to defer to executive branch bureaus on certain matters. This is all about the federal bureaucracies basically running the country and interpreting law. That's what's been happening this whole time. If we remember, last year you had the West Virginia versus EPA case. And in that case, Chevron deference got dealt a blow. They said the EPA cannot just change definitions to make a determined outcome. That was what happened last year. Well, this year they're taking up a case to basically gut the entire principle and overrule it. This is massive. All right. Let's keep going because this would, like I said, just hold on. The High Court announced in its Monday orders it would review the case of Loper Bright Enterprises v. Raimondo, which was filed by anglers who complained that the National Marine Fisheries Service has run amok with a plan to charge fishing vessels as much as $700 a day to hire a monitor to police their catch. So that's the impetus and that's the case. Here's what happened that brought it to the SCOTUS. The anglers lost in a 2-1 federal appeals court ruling in which the majority cited Chevron in deferring to the agency's judgment. We've seen this across the board in every single executive branch bureaucracy. They're doing this and making up laws whole cloth by changing definitions. This is what could be overturned here. It's hard to overstate how important this is. Now, check this out. The court did not note in its order which justices voted to review the dispute, but it took at least 4 justices' interest in weighing whether the High Court should overrule its 1984 precedent in Chevron USA versus Natural Resources Defense Council. That is the point where Chevron gets all of its power. And listen to what Gorsuch, one of the sitting Supreme Court justices, has said prior. Check this out. Justice Neil M. Gorsuch has written in a prior dissent that it was time to do away with the precedent. Quote, "At this late hour, the whole project deserves a tombstone no one can miss," Justice Gorsuch said in a dissent in November. So you have one Supreme Court saying that. You have West Virginia versus EPA ruling against the EPA for Chevron deference. And now you have another case that 4 SCOTUS members have accepted into the actual docket. This is something that could undermine all ATF regulatory authority that they deem through Chevron deference and actually put it back in Congress. This is massive. Let me know what you guys think in the comments below, and I will see you on the next one. I'm Braden. See you later.